close the door. Let your clothes hit the floor. We ain't talk all day, but I know what you came here for. So don't hit me with the shot. We ain't got on.
All right. So, technical glitch there. There wasn't any music playing with that one, but that's okay because I don't want to have to get in any copyright problems anyway. Don't. I got permission. It's just a joke because my guest is all about copywriting and trademarking and patent and everything else you need to do to make sure you're protecting your work once you put it out into the interwebs. So, without further ado, please welcome my guest, Attorney John Rosenthal from Clandestine. Wait, let me make sure I'm saying that right. I'll have them correct me. Clandestine Law.
Blind Dent's PC. That's fine, Camille.
It's PC. Oops. I pressed the wrong button there. Trying to
You
look
got
at the camera as opposed to looking at what I'm doing, and I haven't
you,
mastered it yet.
you
But
got me back.
yes, you're up and ready to go. Thank you so much for being my guest today, and I greatly appreciate it.
I really appreciate being here. Appreciate you having me.
It's my pleasure. Well, let's just get right into it. Tell everyone what exactly it is that you practice as far as law goes, and then we'll find out how you got started.
Okay. Well, I do kind of a whole plethora of things, in particular litigation with a focus on intellectual property litigation. But I also help clients obtain protection of the intellectual property that they own or they want to own. So, intellectual property covers a kind of a broad continuum of things. As you mentioned, one of them is copyright, another is trademark, trade secrets, patents. All of those things could be considered intellectual property. Generally, when people think of property, they think of something that they can touch or feel, like a piece of real estate. Intellectual property is commonly known as intangible property. You can't touch it, you can't feel it usually, but you have rights to it. So, your ideas that you put down in a book, those ideas initially are intangible. Once you put them down in a book and you register that book with the Copyright Office, suddenly you have rights to protect. So, I do, again, uh, litigation generally, but with a focus on intellectual property rights. And I also help clients obtain those rights and whatever kinds of intellectual property they want.
Now, how did you get started in such? I mean, because I know for myself, I don't feel like all of this was even an issue when I was picking out majors. So, how did you even know, or how did you get into um, the kind of law that you practice now? Because it didn't really, well, part of it didn't really exist that long ago.
Some of it did. So that's interesting. I did not go to college to go to law school. I went to college in Northern California. I ended up going into the Marine Corps for 8 years because the Marines pay for college. Had nothing to do with law, had nothing to do with copyright, had nothing to do with painting or art. Matter of fact, I probably couldn't draw a picture of myself to save my life. I'm really not a good artist. But once I got out of the service, I decided to go back to school. Law interested me. I went to law school, practiced in California, in Southern California for a while before going to New York. Most of my practice at that time focused just on litigation, in particular in New York, what's called securities litigation, meaning people suing or being sued over various kinds of investments, stocks, things like that. And just one of the partners in this particular firm I was at in Lower Manhattan, he was an intellectual property lawyer. He focused on copyrights and trademarks. And he said, "Hey, I need some help on a case involving a very famous Italian car manufacturer who was suing one of our clients." And next thing you know, I'm, heavily involved in intellectual property law. So that's kind of how it got started. I didn't mean for it to be that way, but it's ended up being a really interesting and fun practice.
I can imagine. Of course, my mind's wielding like, ooh, what Italian car company? But I guess they lost, so we won't talk about them.
The dispute was resolved amicably, but yeah, it was a very famous Italian car manufacturer.
Does it
They
begin
were
with
up.
an L or F? No, I'm kidding.
I,
Just kidding. I'm not getting you in trouble. I can't afford
that's
the legal
okay.
fees.
I
Da-dum.
appreciate it. So yeah, that's how I got started, and then I'm started practicing with a smaller firm that had a focus on intellectual property up in north of Manhattan, and that's kind of what I've been doing ever since.
Wow. Now, you've had, you, there's been so many different myths when it comes to copyright laws and trademark laws. And we actually talked off camera about a couple of things because even I had wrong information. Can you clear up some of the rumors or misinformation that you've heard from clients or even from myself who didn't know that you can't just mail a copyright?
Sure. So I'll start out with copyright
Okay.
because that's one of the things I focus on. I have a lot of clients, particularly artists, who obtain copyrights or want to copyright their work. But, you know, copyright is actually one of the things, one of the rights that are enshrined in the original Constitution because the founders were very, very mindful of the role that copyright played in kind of the Enlightenment and expanding people's knowledge. Okay. And what copyright is designed to do is if you come up with an idea and put it down on paper or put it down on canvas, they wanted to encourage people to do that. And the only way you encourage somebody to do something is to give them some kind of protection or rights when that product is done or when that thing's done. So basically, copyright is the right of the author or the originator or the creator to prevent others from copying his work and distribute or her work and distributing it. It's the protection of that author or creator's creative content. So we were talking about myths before when we were off camera. One of the myths is something called people, even my artists who are my clients, when they come to me, called the poor man's copyright. And you mentioned it. I created something, either a piece of art or a poem or literature. I stick it in the mail to myself and date it, and don't open the piece of mail when I get it, and I have the copyright. Well, that's a myth. Okay. You have a copyright in your original creation the minute you put pen to paper, the minute you put fingers to, your computer, the minute you start sketching something or put brush to canvas. When it's completed, you own the copyright to that original idea. Okay. Now, you don't own a copyright to the idea, but you own the copyright to the original expression of that idea. So I'll give you an example. The architect who designed the Eiffel Tower, had they wanted to, they could have copyrighted the plans for the building of the Eiffel Tower. Okay, absolutely, architects copyright their plans all the time. Okay, because they want to protect that original design idea that they've now put on a piece of paper or in a computer aided design system or whatever. They can copyright that. Once they do, when we'll get into that later, that's protectable. But let's say I go to Paris and I paint a picture of the Eiffel Tower. Can they sue me for copyright infringement? No, because what I've done is I've had put my original idea onto a canvas, and now I own that. I haven't infringed their design and their architecture plans, right? Because this is the expression of the Eiffel Tower that I created and put on a canvas. So those are kind of the distinctions between what you can protect and not protect in terms of copyright. You can protect your creative original expression of that idea, but you can't protect the idea itself. Another, for instance, is you are a photographer and you take pictures of people, before their wedding with a flower arbor, right? And they're standing in the middle of it. Can you sue everybody who subsequently like puts people who are about to get married under a, an arbor and take a, no, you can't do that.
You'd
That's,
be a
but
millionaire.
right, he'd be a millionaire. But what you can do
Yeah.
is stop people from copying that particular picture that you took of those particular people, because that's an original expression of an idea that you've come up with, that you've created. Okay, so that's the difference.
So
um Go
when you
ahead.
were, I know, I was thinking when you were talking about the Eiffel Tower, it made me think how comedians or musicians, they can get away with redoing other people's songs if it's a parody, or if they're like change up some of the music or something, like to some extent, like there's that murky area to some
Music
extent.
is,
Yeah, but it's a
you're
tough
right,
one.
music is very murky. There are lots of lawsuits over music. It's a particular area of copyright. That we can. I was going to talk about this a little later, but for
Okay.
instance, parody, something called fair use. You cannot sue somebody for copyright infringement if they are engaged in what's considered fair use of your copyright. Again, this goes back to kind of why the founders enshrine the copyright in the Constitution. They wanted to promote science and knowledge, and allowing people to look at your work and then use that to create something else is something that they wanted to promote. Okay. So,
Okay.
for instance, a good example, a little simpler example of fair use is, my piece of art shows up in a book about, impressionist art. Could they sue over that? Probably not, because that book is intended to educate the public, okay,
Mm,
about that particular kind of art and the authors associated with that art. So it's probably fair use, okay? They probably can't get sued over it. Another example is educational books, okay? Or, for instance, the newspaper.
okay.
Your art shows up in the newspaper, right? You probably can't sue the newspaper over their use of your piece of art, because it's fair use. They're using it to educate the public either about you or about a circumstance or something like that that took place.
That's interesting. I had a couple of weeks ago, has it already been a couple of weeks? Well, I had this author on, Marcellus Reynolds, who did this beautiful book about Black models, and pretty much a love letter to their fight and how they gained their notoriety and so on. And he was just talking about how he had to pay like $70,000 in usage just to be able to use pictures that were already made, to get the rights from the photographer and so on. And I was blown away by that. I had no idea. But I guess if he was an education book, then he wouldn't have had to pay $70,000 for
I'll
all of
tell you,
that. Oh,
it's very gray. Okay, so
okay.
again, that's fair use is one of those things that people. It sounds easy when they hear it. When
Okay.
you get into actually being engaged in fair use, or the courts looking over your shoulder about what constitutes fair use, it gets a lot more murky, unfortunately. But yeah,
Okay.
I mean, for instance, movies um, are generally entertainment, generally not considered subject to fair use. Like, for instance, the movies often have to pay, or have manufacturers pay them, right, to put Coke in it, or to put Ferrari in it, or to put a picture in it. Okay, they get a
So there's
release.
the F1. Just kidding.
Yeah, there. That's one of the Italian car manufacturers, right? But there's there's other things. I mean, there have been lawsuits over, matter of fact, very famous African American quilt makers whose quilt showed up in a movie without permission, and they were like, I didn't give you permission to use that. It's a copy. They actually copyrighted the design of their
Oh,
quilt,
wow.
and there was litigation over it. um, Maybe I should go into some of these other things, and I can kind of tell
Yeah,
you
sure.
why or how, or just briefly. So, copyright, and I guess we'll focus on that, is, it's basically literally the right to copy or reproduce something. That's what you get in copyright. So, for instance, do you have a copyright in an original painting? Sure, you own it, but you really don't have anything unless you start reproducing that painting. Posters, postcards, right? That's when you've published that piece of work, okay, and you have the copyright in that. Or creating derivative works, okay? I guess a good one would be a rapper who, creates an original kind of piece of music and then decides that, hey, you know what? I think I'm going to create another piece that, in addition to that, or uses that. You can do that because it's a derivative work. It's derived from your original work. Okay. You distribute copies. You can also display it publicly. Okay. There's another thing or another right that's called moral rights. It's actually established by a piece of legislation called the Visual Artist Rights Act, and it gives artists, particularly artists who display things in public, like graffiti artists, the right of attribution. Like, you can't tell somebody that one artist made that piece of work when in fact you created it. You actually have the right to protect the piece of work against mutilation, and in some instances, there was a big graffiti lawsuit about this. You can actually have the right to protect it to a certain extent from destruction. There's a place called Five Points in Brooklyn, New York. It was kind of an abandoned area, but it had a lot of buildings on it, and graffiti artists were painting graffiti art there with the permission of the owner at the time. And the owner was going to build condos and decided he was going to tear down all the graffiti art and didn't give the artists time to try to figure out how to replicate or take their art or photograph it. And this owner actually destroyed all this art and got sued. And the graffiti artists collected $6.75 million.
Wow.
So that part of the lawsuit was under the Visual Rights Act, because some of these artists were established artists, and they were able to prove that their work was of a recognized stature, which was not that hard to prove because tourists came from all over the world to go take bus trips to go see Five Points and all this unbelievable graffiti art. So that's the Visual Artists' Rights Act is one of these things that protects rights. You can get copyright, like we were talking about, in paintings, books, poems, music, work manuals, advertisements. Those are all copyrightable. They're all original expressions of an idea that you've put down on something. I think one of the things we were talking about is I actually represent a lot of graffiti artists, and their work, some of them relatively famous graffiti artists, but their work was being essentially taken without permission through the internet, right? Someone would go take a picture of their work, post it on the internet, or post it on an image sharing website, and other people would come along and buy it. And next thing you know, it would show up on books, on mugs, on magnets, posters, handbags, you name it. Okay.
Right.
So, I help them protect those rights, require those companies to either take the stuff off or enter into some sort of license agreement so they are being paid for their creation. I'll tell you, Camille, one of the things that's most enjoyable about IP work, particularly with artists, is you have unbelievably talented people who generally are struggling unless they become famous. And of all the people that should get paid for their creations are these artists. And it's great. It's super fulfilling to be able to get them paid for their work, particularly when it's taken without permission, but also to get them recognized. And then next thing you know, companies are coming to them asking, can we license the copyright to your work to put on our tennis shoes, to put on our running shoes, to put on our yoga pants, you name it.
Now, I was thinking when you were talking about that, about, like, let's say someone buys someone's art, that doesn't mean that they have I mean, they could just make several copies of it after then, or put it on mugs, or if it's an individual that buys a piece of art, they're not
That's
licensed to do all of that unless they get permission, correct?
That's correct. That's the beauty of copyright. It's rather than thinking of it as one particular thing, it's kind of a bundle of rights. Okay, so that's a great example. Somebody wants to go buy a painting. They go buy that painting. Well, the artist didn't give up his copyright in that painting. What he sold you is the permission for you to have that one particular piece of work, okay, to hang in your living room, in your dining room, wherever. But that artist could very well have retained the right, registered the work with the Copyright Office, and retains the rights to sell duplications of that. Now, you can enter into agreements, right, in which you commission the work from that artist, you make it a work for what's called a work for hire, and you get the rights from that artist and they don't retain any of those rights. Or the artist can say, listen, I'm going to give you the right to buy this painting from me and the right to replicate it for, posters, but I'm going to retain all the rights to replicate it for women's clothing. I mean, that's the beauty of intellectual property, is you can kind of slice and dice it very narrow, very thin, so that you, the artist, retain some of the rights that you want, but at the same time allowing, people who want to enjoy your work to obtain some of those rights. But that's, you're right. Just because you bought a painting doesn't mean that you can then go replicate it and sell it.
Right. Okay. It's just like if you bought a CD in that same sense, like you can't all of a sudden start making mixtapes off of it.
Absolutely right. You can't
So,
make copies of it without permission. I mean,
yeah.
uh, and you were one of the things about the myth you were talking about in terms
Mhm.
of a poor man's copyright is, and this is really important for artists to be aware of. Even though the minute you put pen to paper or brush to canvas, you own the copyright in that work, until you register that work with the Copyright Office, it's kind of a hollow right, because until you register your work with the Copyright Office, you cannot sue anybody for making copies of it without your permission and selling them. So it's kind of a gatekeeper.
Mhm.
A lot of artists don't know that, or think that this poor man's copyright, they mail themselves this letter and suddenly, now they can sue people. That's actually not accurate. And the Supreme Court ruled uh, this, I think it was end of last year, beginning of this year, that you, in order to sue somebody over copyright infringement, you have to have registered the work with the Copyright Office. Now,
Does that
that
mean
creates a
every piece of art they create? Because how do they know which one someone? I mean, that could get very expensive very quickly, and we all know artists aren't really the top priority as far as getting paid.
it can get very expensive very
Okay.
quickly, depending. Okay, so in order to register your work with the Copyright Office, it costs $45. You go onto their website, you pay the money, you upload your work digitally, and that starts the process. And it takes them anywhere from 3 months to a year, depending on how backlogged they are. Okay, it depends. It also, if you have to send in a physical piece of it, okay, because either it's too complicated to create it in a digital format, or it's some kind of piece of sculpture that you want to sell copies of, something like that, you can send in physical copies to them, and then it's about $125. Um, but it does become an issue with certain artists about, can I afford the $45? Now, what I always say is, why don't you cut out like a Starbucks a couple of times a week, and you're going to have the $45. But one of the things about what a requisite before you can register with the Copyright Office is the piece of art has to be published, okay? Meaning it has to be replicated, it has to be put out in the public. So, for instance, when you go to some of these um, art fairs, or farmers markets where artists are selling their work,
Mhm.
okay, that could be considered publication if they're selling duplicates of that particular piece of work, and they probably, they need to go register that with the Copyright Office. On the other hand, if an artist paints a painting and it's sitting, in their storage bin someplace, and no one's seen it, no one knows about it other than them, arguably that work hasn't been published yet, and so they might not want to register it with the Copyright Office because they don't have to worry about somebody copying it.
Okay.
Um, what if if you upload something onto the internet because you want to post it on your website, or you want to post it on Instagram, right? Then you need to start thinking about registering with the Copyright Office. And real quick, why is this important? Okay. A, because you can't sue anybody unless it's registered, and therefore you can't really protect yourself, even though it's yours. But B, litigation and protecting rights are very expensive. And lawyers are hesitant to take on litigation over copyrights if somebody hasn't registered their work because what happens when you register your work within 3 months of publication, meaning I created it, I went to a farmer's market, I started selling copies, and I registered it with the Copyright Office within 3 months between creating it and publishing it. Now, if you sue somebody and you win, they have to pay your lawyer.
Mm.
So you don't, as the artist, don't come out of pocket. And lawyers are much more prone, it is a business, they're much more prone to take your case if they think, listen, if we sue that big manufacturer that's putting that artist's piece of work on their running shoes, I'm going to get paid at the end of the day, and my client's not going to have to come out of pocket. So it's really important. Register your work, do it as soon as it's published or as soon as you have it out in the public domain.
Okay, I have a couple of questions on copyright before we move on. I know it's
Sure.
almost 2:28, 11:30. If an artist uses the copyright sign next to their signature on a painting, is it protected?
So the answer is no. Okay. Just because you put the copyright on your painting does not mean it's necessarily protected. Again, the key is registration. Okay. That's when you can sue somebody. As a matter of fact, after March 1, 1989, you didn't even have to put the copyright symbol on it on a original creation anymore. I will tell you though, before we get knocked off, there's a piece of legislation, a law called the Digital Millennium Copyright Act, DMCA, okay? That was specifically created as a result of the internet. And even though you don't necessarily get protected if you put that copyright symbol on your work, what you should put on your work is your name, okay? Someplace that identifies you as the creator. Why is that important? Because under that particular law, the Digital Millennium Copyright Act, just that act of putting your name on that piece of original work is called copyright management information. Sounds technical. Just put your name on it. If somebody goes onto the internet and takes down your picture and removes that name, they have now violated that act, and you can sue them even if you haven't registered your work with the Copyright Office. Super important. Put your name or your identifying information someplace on your original creation. My graffiti artists, inevitably, they'll put a tag on it, right? Or their Instagram address, something that identified them, and that's probably sufficient, but super important. Copyright symbol, not so important. Your identifying information somewhere on your original creation, super important.
Okay. Now, see, it's already 2:30. Can I get
Oh,
5 more minutes?
sure, absolutely.
Okay. Okay. So I'm curious because you've helped me on the modeling side of that, where in the sense that somebody took my photos and decided to sell them to other people. And I
Right.
think that's something that happens more often than not, as far as just people just stealing images off of Instagram, whether they're a model or not a model. But how can people protect themselves, or when should they reach out to you or an attorney in regards to these manners as well, just for the actors and models and public figures, influencers that are out there that are tired of getting their work stolen?
Got it. So
Yeah.
there are laws in a couple of states, not all states, that are laws that define the right of publicity, okay, or right of personality. And California has one, New York has one. Not all states have them, particular laws, but many do, okay? And basically, what that says is unless you have the consent of the person whose image, signature, likeness, voice you're using for a commercial purpose, if they use it, they violated that particular law as to you, and you can actually sue them. Now, is it going to be a lot of money? No, most of the laws are, $750 up to or up to $500, but you can sue them. You can require them to take it down, and that's one of the ways you protect yourself. Okay, so the exception to that is, though, again, newspapers. Okay, the newspaper uses your image in the newspaper to talk about a particular story that involves you or some activity you're involved in. You can't sue them for violating your right of publicity, okay, because it's newsworthy. But yeah, that's one of the things. Again, the caveat is that they're using it for a commercial purpose. So, for instance, a uh, a website has put up your image on there to sell, tickets to an activity and you didn't consent to that, that's arguably a violation of your right to publicity. Okay. So that's something you could cause somebody to probably take down. If somebody puts something on Instagram that where they're not really trying to sell anything, or they're not really using it for some sort of commercial purpose, it might not, even though it might violate your rights, it's not something you could probably sue over because they haven't really used it for a commercial purpose. That's kind of the difference.
Okay.
But
Okay.
it's definitely something worth looking into, particularly if you're famous, popular, you have a following. People should not be using your image without your consent, and you can reach out to them and ask them to take it down. That's another provision of the Digital Millennium Copyright Act, is something called a takedown notice. You basically send the website owner where the image is being displayed, telling them, listen, this is my image or this is my copyrighted work. I didn't give this person consent to use it. Please take it down. They're generally required to take it down. And the caveat is that as long as they do it in a relatively quick manner, you can't sue that website, which is kind of why that act was put into place. It gives the website owners kind of a safe harbor.
Very good. And just very briefly, since you said you have 5 minutes and I have like 30 seconds left,
Okay.
there's a lady who's currently getting a lot of flack, and I won't say her name because people already know who I'm talking about that she stole printables from Pinterest, exact same font, exact same wording, everything was exact same. I don't even think she changed the colors. And it was created by other influencers. If they didn't copyright it, but they put it on Pinterest, something that's like a public trading site, and they put it and someone else decides to take that and put it in a book, is that illegal?
It really depends. I mean, I hate to say that.
Yeah. Okay.
If you didn't copyright it, you probably don't have any rights in it. Um, Again, copyright is, can you copyright a slogan? Probably not. Okay. Because it's not original to you. Okay. Again, copyright only applies to something that you originally created. Now, if you put that slogan and created it out of, flowers in a very particular manner with a very particular background, could you claim copyright in that entire image? Yeah, that's possible. Okay. But you probably couldn't claim a copyright as to that. The wording and fonts are generally not copyrightable. Okay. Generally, not always. It depends on how particular they are, what the original idea is. But, you can't get a copyright in a letter, for instance. Okay. They're not going to, the Copyright Office isn't going to say nobody else on the planet can use the word "why."
Okay. And
So,
one quick
or,
thing, I know it's
yeah.
just because we talked about this off air and we didn't get to bring it up, but for screenwriters who are sending out their scripts to different people now to
Oh,
try to get made into movies, because right now people are really reaching out to people of color and wanting them to be involved in filming, and they're asking for their scripts and so on. What safety precautions should they take before they just send over a script to who knows who, without the fear that it could end up that they could just steal their script and make it their own?
so a couple of things. First, you might want to register it with the Copyright Office as an unpublished work to protect yourself. Okay.
Okay.
Again, it's $45, but it's well invested. You might want to talk to a lawyer if you're being talked to by very significant movie companies about it. Okay. Penny wise, pound foolish. Okay. You definitely want to talk to a lawyer. The other thing is, as we were talking about, there's something called a non-disclosure agreement, an NDA. You might want to enter into an NDA with this movie maker, movie producer, so that when you provide your script to them, this NDA specifically says, I'm only giving this to you for purposes of evaluating whether you want to either buy it from me or enter into some kind of license agreement with me, and for no other purpose. And that's one of the ways you can protect yourself. But I would definitely talk to a lawyer. I would definitely think about registering it with the Copyright Office, even as an unpublished work. And NDAs are something that screenwriters probably should be aware of.
Fantastic. Thank you so much for taking this time out of your very busy day. And I hope this doesn't count as my billable hours. Just
It
kidding.
definitely doesn't. I'm always available to you, Camille.
Oh,
You're
thank you.
fantastic.
I
Uh,
appreciate you.
yeah, thank you very much for having me. I really a pleasure.
Oh no, it was my pleasure. I learned so much. Every time I talk to you, I learn so much. So I really appreciate that you giving the time so others can learn as well from you. And by the way, how can everyone reach you or find you if they need you? What would be the best way for them to contact you?
So if you Google my name, John Rosenthal,
Mhm.
or the law firm is Kleindenst, Klinedinst, you'll find us and you'll find me.
Okay, I'll put that in. Thank you so much again. You've been awesome as usual, and I appreciate you spending the time with me this afternoon. Well,
Great.
it's
I
not
appreciate it.
afternoon with you yet. You're still in California
Yeah,
time.
it's almost afternoon, but I
Okay.
appreciate it. And thanks for having me on. Okay.
Oh, it was my pleasure. Have a great rest of your day, and we'll talk soon.
Take care.
Okay. Bye bye. So much great information. I hope this has been just as helpful for you as it was for me. And I'm going to make sure I put right now in the directory, I'm not in the directory, in the comments so you can find Mr. John after this because he is so helpful. And honestly, when I reached out to him about my own legal affairs, I was just curious how I could get it down. Next thing you know, he did way more than that. Oh, great. Now I can't, it's not letting me copy and paste. So I will post his information on my Facebook page so that you can reach up to him that way. Third party apps, man, you never know what's going to happen. So, anyway, I will see you guys again at 7 o'clock. Do not miss it. I will be with Dr. Lane Rowling. He will be back telling us the latest about COVID-19. He was on before about 3 weeks ago, and he predicted that we would have another peak. And where are we? Another peak. And that was before all the protests and things opening back up and people going to races and all these other different things where they may or may not have been wearing masks. So I'm very curious what his thoughts are now and how we can move forward as far as protecting ourselves. And hopefully there's some new information that maybe he can even share since science moves fast. You know, you just never know what new information that maybe hasn't been released yet that's could be helpful. So I know as a parent, I'm very curious because I've seen a lot of things about schools opening up in August, but I haven't seen a lot of things about what kind of precautions they're going to take to make sure that's safe for everyone that is going to these schools. Because there's a lot of, I feel like I see a lot of people who work there who are over the age 50 that may be in a higher risk group. But then you have people who have special ailments that we can't see that might be in the high risk group. So I'm just very curious what his thoughts are, and even with set like with film opening back up, what precautions are they taking that are really necessary and what is just lip service that doesn't really need to be done. And those are all things to think about. And even with sports getting ready to open back up as well, I wonder what he's thinking and what we can do to make sure we're all staying safe. Anyway, tune in at 7 o'clock tonight, 4 o'clock West Coast time. I'll see you guys then, and you have a great rest of your day. See you tonight.